The Senate Committee on Health, Education, Labor, and Pensions will come to order. Good morning. Today's hearing marks the committee's seventh this Congress on the reauthorization of the Higher Education Act. This morning, we will be discussing sexual assault on college campuses and legislative proposals aimed at lessening this crime and providing justice for the survivors and alleged perpetrators. Before we begin, I would like to share a brief statement from Chairman Lamar Alexander, who asked me to read the following. I've asked Senator Collins to chair today's hearing because I have had to go to Nashville for the funeral of a close friend. Before she was elected to the Senate, Senator Collins worked at Hudson University in Bangor, Maine, so she brings a valuable perspective to this discussion. Always weird to be reading what someone else is saying about you, I thank her for doing this, and I thank the witnesses for attending. The goal of federal regulations and rules should be to help our 6,000 colleges and universities create campus environments that make students safer from sexual assault. In doing that, we should be careful to, 1, eliminate duplicative laws and regulations so that instead of spending unnecessary time filling out forms, colleges have more time to counsel students and create a safer environment. 2, help colleges better coordinate with law enforcement agencies, but not turn colleges into law enforcement agencies. And 3, establish procedures that are fair and that protect the due process rights of both the accused and the accuser. I know that the chairman regrets very much that he could not be here today, and I would ask that the remainder of his full statement be printed in the record. One of the things that I most enjoy as the United States Senator is the opportunity to meet with students from my home state of Maine, a sentiment that I'm sure that many of my colleagues share. Yesterday, I had breakfast with my summer interns who attend 6 different colleges and universities. We discussed the incidents of sexual assault on their campuses and what can be done to halt this crime and meet the needs of survivors. These students had 3 insightful recommendations. First, they all support mandatory ongoing training for all students. Second, they emphasize that students who are assaulted need a confidential advisor to whom they can turn. And third, as Chairman Alexander mentioned, they believed it was important to make sure that disciplinary procedures are fair, both for those who are assaulted and for those who are accused. There are 2 federal laws to help combat sexual assault on campuses: the Clery Act and Title IX of the Education Amendments of 1972. Last Congress, provisions of the Clery Act were updated by the enactment of the Violence Against Women Act reauthorization. Senator Casey, a member of this committee, helped lead the effort to include important reforms in VAWA related to sexual assault prevention on campuses. On July 1st, the Department of Education issued new regulations implementing these amendments to ensure that campuses have policies and procedures in place to prevent and respond to sexual assault, domestic violence, dating violence, and stalking. These laws include requirements that educational institutions file annual reports on the crimes occurring on campus, institute security policies, and have fair disciplinary procedures for sexual assault cases, employ a Title IX coordinator, educate students and staff about sexual assault prevention and awareness, notify survivors about their rights and the resources available to them, and provide for staff training. Many colleges and universities are also engaged proactively in raising awareness about sexual assault among the student body. For example, the University of Maine launched its Office of Sexual Assault and Violence Prevention last year and has undertaken a campaign to educate students through posters, brochures, presentations, and training. Mercedes Dubé, an intern in my office and a senior at the University of Southern Maine, who happens to hail from my hometown of Caribou, told me that the Office of Greek Life requires students in sororities and fraternities to participate in sexual assault, domestic violence, and alcohol and drug awareness training each year. The system we have in place is designed to allow administrators to intervene quickly on behalf of students in a way that is separate from the judicial system. I hope that this hearing will inform the committee of what in the current system is working, what needs to be changed, and whether additional reforms are needed to help keep students safe while respecting the privacy of sexual assault survivors who may be reluctant to report these crimes, and providing due process rights for all students. This committee has formed a bipartisan working group to explore campus sexual assault and campus safety in greater detail. I look forward to hearing from our witnesses on how we can build consensus around this important issue. Our first panel today is comprised of 4 senators who have worked tirelessly together on legislation to combat campus sexual assault and have introduced the Campus Accountability and Safety Act. Senators McCaskill, Heller, Gillibrand, and Ayotte are 4 of the original co-sponsors of this bill and have devoted a great deal of time and energy to this effort. I also want to recognize the work of Senators Blumenthal, Grassley, Warner, and Rubio. The Campus Accountability and Safety Act includes several provisions that merit our full consideration. All of the senators who will be testifying have shown great leadership in addressing campus sexual assault, and I want to thank each of them for their participation this morning. It's now my great pleasure to turn to the ranking member, Senator Murray. Senator Murray, I will say this feels like old times when we led the Transportation HUD Appropriations Subcommittee.
Well, thank you very much, Madam Chairman. It's great to be working with you on this committee. I note that the women of the Senate have come today to be on time and to be here for this. I want to thank all of our witnesses as well who represent a wide array of perspectives and appreciate all of you for taking the time to join us. I think join with Senator Collins in recognizing the work of our first 4 witnesses, Senator McCaskill, Heller, Gillibrand, and Ayotte, for all of your time and attention to this really critical issue. Fighting back against campus sexual assault and violence really requires coordination and input and focus at every level. So I'm grateful that all of our witnesses took the time to be here today to talk about this. I said before, higher education is an important pathway to the middle class. It's an opportunity for students to grow personally and to develop skills that will prepare them to succeed in today's economy. With all of that to focus on, the last thing a student should have to worry about is whether they are safe on campus. But the harsh reality is that 1 out of 5 women is sexually assaulted in college, and men as well. In 2013 alone, college campuses reported 5,000 forcible sex offenses, and a recent study indicated that number could be much greater. So there should be no question that sexual violence on campus is a widespread, growing, and unacceptable problem. Simply put, in colleges and universities across the country, basic human rights are being violated. And all too often, current systems and campus climates encourage underreporting rather than action. As we talk about the seriousness of this problem, it's important to acknowledge the work already underway to address it. Survivors like Ms. Dana Bolger, who's a witness on our second panel, have bravely stepped up to make clear they expect far better from their schools and their communities. In doing so, they have forced a national conversation, and they've shown other survivors they're not alone. President Napolitano, great to have you here today. Ms. Flohnlacker and other university leaders have made fighting campus sexual assault a top priority. They have developed new partnerships between schools and communities and law enforcement to coordinate and improve response, and taken important steps to focus on prevention and improve compliance with the Clery Act, which is something Ms. Stafford has worked on closely. Just last month, thanks to the work of many here today, including Senator Casey, a member of this committee, regulations went into effect as part of the Violence Against Women Act of 2013 that will require schools to increase transparency about sexual violence and assault and strengthen prevention efforts. These are critical steps, but without question, there is much, much more to be done. So I see our conversation about reauthorizing Higher Education Act as a critical opportunity for continued and urgently needed progress. I'm very pleased that key Senate leaders are here today with us to discuss their Campus Accountability and Safety Act legislation that would take steps to improve campus climate by requiring far greater transparency about the prevalence of campus sexual assault, put in place key protections for survivors, improve coordination with law enforcement, and impose harsher penalties on schools that are not meeting requirements. So as a mother and a grandmother and a United States Senator, I certainly want to know that when a student is attacked, her school and her community will be ready to respond with compassion, with respect, and with accountability. But I think we can all agree we need to do everything we can to engage students and schools so that sexual assaults don't happen in the first place. Recent research by the Centers for Disease Control and Prevention, which is part of the administration's ongoing efforts, has identified campus sexual assault as a public health issue and has shown that sustained comprehensive education programs can help prevent sexual assault, especially by preparing students to fight back against the damaging myths that surround rape and assault. And efforts to encourage bystander intervention can help break down social norms that implicitly sanction sexual violence. I am very eager to hear from all of our witnesses today about programs and policies aimed at prevention. But of course, as much more effective programs and requirements can make a huge difference, we cannot expect to fix this problem just by changing the rules. We have to do something much more difficult, and that is to change culture. For example, just a few years ago, Ms. Bolger brought to light the fact that at her alma mater, Amherst College, a fraternity had printed T-shirts depicting a woman being roasted on a spit like a pig. Those students went unpunished. Take a minute to think about the message that sends to students, male and female, about how much their community values women. And unfortunately, this is just one example of countless to choose from across the country. That's why the national conversation that students like Ms. Bolger have started and that other leaders, including many here today, have stepped up to support is so absolutely critical. A country that values women and all individuals is stronger for it. So we all need to do our part to keep this conversation going, and we need to make it louder. We've done far too little in Congress over the years to support survivors and to be a voice for women across the country, daughters and granddaughters who are counting on us. So I'm glad that Chairman Alexander and I agree that the HELP Committee needs to join the debate on campus sexual assault much more fully. So again, I want to thank all of our witnesses, including our colleagues who are here today, for taking the time to be such a critical part of this discussion and the work that all of you have already done with many other members on both sides of the aisle who are very much focused on this fight. As we continue our conversation about our country's higher education system and throughout our work on this committee, we have an opportunity to stand up for survivors, make clear the status quo is completely unacceptable, and help continue the conversation about changes we absolutely need to see. I am very committed to seizing this opportunity. I want to thank Senator Collins for being here today, and I want to recognize Senator Alexander as chairman of this committee to stepping up to this. So thank you all very much.
Thank you, Senator Murray. I'm now very pleased to welcome our colleagues as the first panel of witnesses today. Missouri Senator Claire McCaskill has a long history of fighting sexual violence going back to when she prosecuted sex crimes and established a domestic violence unit in Kansas City region, and leading to her current work in the Senate to curb sexual assaults in the military and on college campuses. She is the lead on the Campus Accountability and Safety Act. Nevada Senator Dean Heller has been an advocate for sexual assault survivors since his tenure in the House of Representatives, where he led a bipartisan effort to reduce the rape kit backlog and to help bring closure to victims and families of this horrendous crime. New York Senator Kirsten Gillibrand has been a key voice on the issue of sexual assault on college campuses and also in the military, particularly in her role on the Senate Armed Services Committee. And New Hampshire Senator Kelly Ayotte, drawing on her experience as New Hampshire's chief prosecutor and former attorney general, has also worked hard in the Senate to stop sexual assault and domestic violence. Thank you all for being here today, and we'll start with Senator McCaskill.
Thank you very much, Chairman Collins and Ranking Member Murray, for holding this important hearing on this issue. These crimes are troubling to parents, students, and educators. As a mother and a grandmother, but maybe most importantly, informed by my former work of many years in the courtroom prosecuting sex crimes, I'm working extensively with my Senate colleagues to ensure students are protected from incidents of sexual violence and perpetrators are held accountable. I'm very proud to work with Senator Heller, Gillibrand, Ayotte, Grassley, Blumenthal, Warner, and Rubio. We introduced last year a version of the Campus Accountability or Safety Act, or CASA. But we didn't stop with the version that we introduced last year. Over the past 15 months, our coalition of 8 offices has met with over 60 organizations, including groups representing students who have been victims of college sexual assault, colleges and universities, and their associations, law enforcement, victim advocacy, researchers, and parents of those children, of those young people who have been accused of sexual assault on college campuses. After introducing last year's version of CASA in July of 2014, as we continue to meet with stakeholders and gather additional feedback, we have, I think, made significant improvements to the bill. We have reintroduced this bill with an even larger bipartisan coalition. Currently, the bill has 33 co-sponsors, 12 Democrats and 12 Republicans and 21 Democrats. That's a bipartisan coalition we all know we don't see every day in the United States Senate. And our legislation is so much stronger for it. We are all enormously proud of the work we have done together. Finally, we want to bring this crime out from the shadows and make it a priority on our nation's campuses. As a former prosecutor, I take special interest in assuring that those who have been victimized by sexual assault are given adequate support and feel empowered to make informed decisions in a very complicated situation. There are different systems. There is the legal system and there's Title IX. There are different obligations depending on who learns of the crime. These young people need to have information they can rely on as they navigate this complicated scenario. At a moment, they are traumatized, emotional, and really are worried they have no place to turn for reliable information or where they will be treated with credibility. Our legislation would establish new campus resources and support services for victims who are alleging they have been victims of sexual assault. Colleges and universities would be required to designate confidential advisors to these students. The confidential advisor, I think, may be the most important part of our legislation. This is a person that guides the student through the process of understanding the potential legal and campus reporting processes, following a sexual assault and can provide confidentiality through that process. Not only would the confidential advisor coordinate support services for those who have been assaulted, they would provide critical information about options for reporting these crimes to campus authorities and/or local law enforcement. Confidential advisors will support the students every step of the way and will put them back in charge of what happens to them moving forward. We have heard from advocates and those who have been assaulted that they need someone they can talk to in order to learn about their options without being forced to make a permanent decision right away. Because the confidential advisor works solely at the discretion of those who have been assaulted and provides important information on reporting sexual assault, I believe their creation is critical to tackling the underreporting that pervades this issue and leaves perpetrators unaccountable. It's my hope that this provision empowers a student who is assaulted on a Friday night to know on that same Friday night who he or she can call and where he or she can go for good information and confidential support. I also want to mention that our bill now includes a provision to ensure more transparency about the campus judicial process. Our bill requires that both the victim and the accused have timely notice of an institution's decision to proceed with an institutional disciplinary process regarding an allegation of sexual misconduct. This would provide both the victim and the accused student with the opportunity to meaningfully exercise the rights afforded to them under institutional policy. It is critically important that both of the parties participate on a level playing field in the campus disciplinary process. We must continue to work to improve confidence in the judicial and campus systems, which will in turn increase reporting, support survivors, and punish perpetrators of sexual assault on our college campuses. In addition, we must make sure that these provisions provide transparency for those who are accused. I look forward to working with my Senate colleagues and members of this committee on the provisions of this bill and the larger Campus Accountability and Safety Act in the coming months. We think that there is, between all of us that have worked on this and all of the input that we have taken, we believe there are several key provisions that could be included in the reauthorization of higher education that could make a real difference going forward. And we really appreciate this committee taking the time to deal with it today. We've tried to divide up the testimony in a way that we won't be too repetitive, and I hope we won't. We really it's hard for us not all to want to be here, so we really appreciate you putting up with all four of us wanting to get our words in this morning. Thank you.
Senator Heller.
Chairman Collins and Ranking Member Murray, I want to thank you for the opportunity to testify on this particular issue that I think is critically important. But most important, I want to thank you for your opening statements from both of you, for your understanding, concern, and support of moving something forward here so that we can make sure that these campuses are safe. I'm proud to work along with my colleagues here. Glad to see after Senator Murray's comments that there are more male senators that have shown up. It was lonely for a while, but I assure you that there are other male senators that are just as interested and devoted to this issue as I am. When we first started working on this legislation, it was important for me to sit down with stakeholders in the state of Nevada. Last June, I held a roundtable in Las Vegas. I received inputs from Title IX coordinators, from police officers, victims advocacy groups on ways to prevent sexual assault and assist student survivors. I brought their ideas back to Washington, as my colleagues did the same in their states. Much of the feedback helped us draft our first bill, and this is only one example of outreach that most senators do. Since the first introduction of our bill, our bipartisan working group continued to meet with stakeholders across the nation, including survivors groups, students, colleges and universities, law enforcement, and others to help strengthen and improve our new bill that we introduced earlier this year. From the beginning, we've also worked diligently with your committee to ensure our final bill incorporated comments from experts on our nation's educational system. Our working group strongly believes we have put together a comprehensive product that will provide our schools with the tools that they need to make our campuses safer. I know for me and for many parents, watching your children go off to college is one of your prouder moments. But parents want to be confident that their sons and daughters will be safe and have access to resources that they need from their schools. Unfortunately, it's not always the case. Today, we have over 100 colleges and universities under investigation for violation of Title IX in their handling of campus sexual violence. And while we've all seen news stories after news stories about these tragic events, the reality is there are many more survivor stories that haven't been heard and haven't been told. Sexual assault is a crime that more often than not goes unreported, which is one of the reasons why data provided by our nation's institutions simply do not reflect the prevalence of this crime. In fact, there are many colleges and universities that have reported 0 incidences of sexual assault to the federal government. I strongly believe one of the most important provisions of our bill is the Campus Climate Survey. This survey will improve access to accuracy, campus-level data by allowing students to anonymously share their experiences related to sexual assault. Under our bill, schools will give their students anonymous online surveys to gauge the scope of sexual assault on campus and the effectiveness of the current institutional policies on this issue. The Department of Education will be responsible for developing this survey as well as picking up its costs. Schools just need to ensure an adequate, random, and representative sample of students taking the survey. The survey results will be reported to Congress, published on the Department of Education's website. Because this survey will be standardized, the American public will be able to compare the campus climates of all schools. As a father of 4 children, I wish I had access to this kind of information when my kids were preparing to go to college. And now, as a grandfather of 2, my hope is that when they grow up and go off to school, our nation's campuses will be safer than ever before. The Campus Climate Survey will be useful, an educational tool for both students and parents, as well as an invaluable resource for institutions to help create or enhance efforts to prevent sexual assault, assist survivors of this crime, and improve campus safety overall. This provision is just one example of how Congress can act today and make ending this crime a priority. While Congress cannot legislate away sexual assault and no bill is perfect, I believe the Campus Accountability Safety Act is a step in the right direction towards combating this heinous crime, guaranteeing survivors have access to the resources that they need and deserve. So thank you again for the opportunity to testify today. I look forward to hearing from my colleagues that are here at the witness table, and it has been an absolute honor and pleasure to serve with them and work with them to get this work done. So thank you very much.
Thank you, Senator. Senator Gillibrand.
Well, thank you, Chairwoman Collins and Ranking Member Murray. I'm so grateful for your attention on this issue, your commitment to this issue. I'm also grateful for Chairman Alexander's interest in having this hearing. It is invaluable. About a year ago, we outlined a path forward to protect students from campus sexual violence, and we heard from survivors who spoke very passionately about not only the harm and physical assault they endured, but the second injustice, the injustice of feeling betrayed by a school that they loved, an administration that they trusted. We listened to law enforcement, we talked to campus officials, we talked to the advocates for the rights of the accused, all who wanted their voices heard. And so, as Senator McCaskill said, this bill, this second bill that we've introduced, is truly a superior version of the first bill. This bill, its fundamental objective is to flip the incentives so that the first time it would actually be in the school's best interest to solve the problem, to actually do it aggressively and get it right. We did it because obviously the price of a college education should never be the risk of a sexual assault. Every day it's becoming increasingly clear that too many schools are failing because they do not take sexual assault seriously enough. They do not see it as the violent felony that it actually is. They do not treat these as life-altering assaults, and they don't treat them as violent crimes. Schools all across the country will routinely withhold a diploma if you don't pay your fees. They'll routinely kick you out if you cheat on a test. But the statistics for students who have violated other students, who have sexually assaulted or raped them and found responsible, show that only 1/3 are actually expelled for the crime. In other words, 2/3 of students who were found responsible for sexual assault are still on their college campuses. What does it say about our school's priorities if some colleges have tougher justice for a student cheating on an exam than for someone who has raped another student? The Campus Accountability and Safety Act would transform the way colleges and universities deal with this crime. With this bill, instead of pretending these crimes don't happen, schools would be held accountable for reporting their sexual assault statistics accurately and publicly. Every college and university in the country would give their students an anonymous standardized survey to assess students' experiences with campus sexual violence. The results of this biennial survey would give students, parents, and campus administrators a snapshot in time of what's happening on their campuses that would paint a far more comprehensive picture of the scope and depth of this national problem. With this bill, instead of having campus security and local police debate jurisdiction after a sexual assault is reported, every college and university in the country would be required to have a memorandum of understanding with local law enforcement to clearly delineate responsibilities. So as Senator McCaskill said, when you go and see that confidential advisor, he or she will able to tell that survivor what his or her options are. This is the campus route, this is the criminal justice route. There'll be no confusion, and she'll know exactly what happens under each process. And instead of a survivor feeling like she has to go public with the details of her rape just to capture her school's attention, with this bill, she now has a dignified path to justice without having to broadcast the details of the worst nightmare of her life in public and on the cover of the New York Times. So I urge my colleagues here to support this critically important bill. I truly believe we have a responsibility to keep our young men and women safe on campus. And Chairwoman Collins, I have, for the record, a number of letters that I'd like to introduce. I have one from the American Federation of Teachers. I have one from the anti-sexual violence organization RAIN, one from my state University of New York system of 64 colleges and universities, the largest in the country, who has endorsed every provision of this bill. I also have one from the representatives from the Louisiana legislature, where a version of the Campus Accountability and Safety Act recently just passed into law. And I have another one from the student advocacy organization called SAFER, Students Active for Ending Rape. Thank you again for your attention and your dedication, and thank you to all the members who came to this hearing. Thank you.
Thank you for your testimony, and those letters will be entered into the record without objection. Senator Ayotte.
Thank you, Chairman Collins. Thank you, Ranking Member Murray. I want to thank Chairman Alexander as well for his focus on this issue. And I know that many members of this committee have already become co-sponsors of our bill and have been real leaders on this issue. So we're very appreciative of your attention today. I'm deeply honored to be here with my colleagues, and this has been an important process of continuing to seek feedback on making sure that we are looking at the best practices that occur around the country and also solving some of the worst problems that we've seen and inconsistencies that we've seen around the country. So thank you all for your leadership on this. This, I think, is an example of how members of both parties can work together when you see the strong bipartisan support for this bill and also the strong, I think, bipartisan message that this hearing sends today, that we all appreciate that every student deserves a safe environment on campus so that students can focus on learning instead of being victims of crime or feeling that they have to be in fear. And that's really what we want to accomplish, and to give the proper tools and focus on this incredibly important issue. Campus sexual assault is a serious public safety issue that has impacted every state in this nation, including my home state of New Hampshire. And so, like Senator Heller, in order to hear directly from stakeholders, I've held roundtables and discussions on this issue at Dartmouth College, St. Anselm College, and the University of New Hampshire, bringing together students, survivor advocacy organizations, law enforcement, and campus administration officials to talk about these issues in different size colleges with different challenges. In New Hampshire, we have seen some positive developments when it comes to ensuring that survivors receive support on campus. And I think that this national discussion has forced many colleges to really focus on this issue. So I think having a hearing like this also causes our campuses to again re-examine this issue. For example, having met with local law enforcement and administrators and students at Dartmouth College in Hanover, I know that they are engaged in a process and committed to change at Dartmouth. And I've also had very candid conversations with the administration there. The Dartmouth community has struggled with this issue, and there's much more work to do. But I'm very encouraged that Dartmouth recently formalized a relationship with the local Rape Crisis Center to provide confidential services to survivors of campus sexual assault. Over in Durham at the University of New Hampshire, they've actually done some nationally recognized work for their on rape prevention. And candidly, much of the focus of our legislation is to ultimately bring campus communities throughout the nation in line with some of the efforts that we've seen at UNH. UNH Police Chief Paul Dean proudly characterizes UNH's multiple initiatives on prevention and response as a conspiracy of care for the students at UNH. As a former Attorney General in my state, I know that crimes of sexual assault are very serious crimes and need to be handled by law enforcement if victims choose to pursue that route. However, the reality is that for a variety of reasons, these crimes are vastly underreported and often unreported. And our bill seeks to foster a more cooperative environment between schools and local law enforcement by requiring colleges and universities to enter what Senator Gillibrand talked about, a memorandum of understanding with the entity that has jurisdiction to report and investigate crimes on campus. The goal of the MOU is to foster a dialogue between the school and law enforcement before a serious incident takes place, an MOU that clearly delineates responsibilities and requires appropriate information sharing can ensure that survivors who come forward and choose to report a crime to law enforcement, that these crimes are properly investigated. It also can ensure that an accused individual, that there's a clear understanding of what their rights are in this process as well. We know that too many of these crimes go unreported on campus, and that's why it's so critical, this piece of the confidential advisor, so that victims know what their options are and that they know that there is someone who can represent them in this process and can let them know what their options are if they choose to report to law enforcement or if they, and what will happen during the administrative process. These two provisions, I think, are critical as you look at this bill. And unfortunately, one other issue that came up during the course of bringing people together around this, and I know Senator McCaskill has focused on this as well, we've been very outraged that we found out that on some campuses, the way that these crimes have been haphazardly investigated, that you had athletic departments that were investigating crimes of sexual assault and handling these matters. And so consistency in ensuring that practices like this never occur again will ensure the fairness not only to the accused but also to victims of sexual assault. So you can imagine if you're a victim and the athletic department is the one investigating an athlete that is accused of these crimes, that you will not feel that you'll get justice in those circumstances. And this bill would end practices like this and ensure that there's consistency and that there's fairness, not only for victims of sexual assault, to ensure that a confidential advisor will be given to victims, but that the accused, that there's a fair and clear process to investigate these crimes. I thank you so much for your leadership, both the chair and ranking member on this issue, and for my colleagues and their incredible work today. Thank you.
Thank you very much. I want to thank all four of our colleagues for coming to testify today and for your outstanding leadership on this issue. I know you have busy schedules, so at this point you're free to go, and we'll bring forth the second panel. I am pleased to welcome our next panel of four witnesses today. Our first witness, President Janet Napolitano, is the president of the University of California. I had the pleasure of working with President Napolitano when she was Secretary of Homeland Security, and I served as ranking member of the Senate Homeland Security Committee. It's a pleasure to welcome her back to Washington today. President Napolitano leads a university system with 10 campuses, 5 medical centers, 3 affiliated national labs, and a statewide agricultural and natural resources program. Previously, she served as governor and attorney general, not at the same time, I might add, of Arizona. Our second witness, Dana Bolger, is the co-founder of Know Your Nine. She leads a national survivor and youth-led campaign to end campus sexual and dating violence. She's also a columnist and a 2014 graduate of Amherst College. We thank you for being here as well. Next, we will hear from Dolores Stafford, who is the Executive Director of the National Association of Clery Compliance Officers and Professionals, an association for campus administrators who are responsible for managing Clery Act compliance. She also serves as the president and CEO of D. Stanford and Associates, a professional services firm specializing in safety and security related issues on college campuses. It's also interesting to note that she served as chief of police at George Washington University for several years right here in Washington. And finally, we will hear from Molly Benz Flownlocker. There, I got it correct. Who is the Associate Vice President for Federal Relations at the Association of American Universities, where she has worked for some 14 years. She's responsible for higher education policy and funding issues. Governor Napolitano, we will begin with you.
Well, thank you, Senator Collins, Senator Murray, and members of the committee for holding this hearing and for the statements of your colleagues earlier this morning as well. I'm really pleased to see the bipartisan support on this issue. Campus sexual assault, sexual violence, it's a criminal issue, it is a public health issue, it is a cultural issue. At the University of California, which is the nation's largest public research university, we have no tolerance for it. The question is, what do you do about it? So I'm here today to briefly describe what we have done and make just a few brief comments on the legislation. In June of 2014, we established a system-wide task force to develop and implement a model for prevention, response, and reporting of incidents of sexual violence and sexual assault. We broadened the definition to include things like dating violence, domestic violence, and stalking, which previously had not been clearly included. And we adopted an affirmative consent standard, meaning consent must be knowing, intentional, and revocable in our cases. The task force, which was very broad, but identified 8 key recommendations, and I'm pleased to see that the recommendations of the task force are really mirrored in the legislation that you are considering now. A consistent response team, system-wide investigation and adjudication standards, including sanctions, comprehensive training and education for the entire UC community, communications and public awareness, a confidential advocacy and advocate for each survivor, a system-wide website for information, standard data collection and increased accountability and reporting, and then appropriate support services for survivors based on their circumstances. Those are the 8 key pillars of what we are doing. 4 have already been completely enacted. The remaining 4 will be implemented no later than January of 2016. The most important, I think, is we have established the independent confidential advocate on every campus of the University of California. We have funded it, we have supported it, we have trained it. We've also set up system-wide education. Every person, every freshman reporting this fall will receive the same training throughout the system, and that training will then include all other students, faculty, and staff. When you add all those numbers together, that's over 400,000 people will be receiving the training. We have worked with the California Attorney General on a model, a template, and a toolkit for the linkage between the campuses and district attorneys and law enforcement. And the websites are up and running, and in my written testimony, I've given you the website if you have extra time, which you don't, but if you have, you could go on the website. A couple brief comments on the legislation. First of all, 3 principles. It has to be flexible enough to allow for institutional differences. There's a big difference between a big public university like a Berkeley or a UCLA and a very small college, and we need to take some of that into account. Second, existing rules and regulations within the Department of Education need to be better allocated and coordinated. There's a lot of redundancy, duplication, and delay there. And this is something I know the department is working on, but it is something that should be taken into account. And third, any new laws should not undo any research-based best practices already implemented at campuses across the country. In other words, campuses are moving even while the legislative process is underway. As I've mentioned, I think we are very close to voluntary compliance with the key elements of CASA. One thing, last point, on the MOUs. The legislation should recognize that many large campuses have their own sworn police departments. And so how that works in the MOU world needs to be taken into account legislatively. But again, I think the importance of this hearing and the importance of the support shown in the Senate for this legislation cannot be overstated. And on behalf of the University of California, we're very grateful for your efforts.
Thank you very much for your excellent testimony. Ms. Bolger, welcome.
Thank you, and good morning, Chairman Collins, Ranking Member Murray, and members of the committee. I'm very grateful to be here to testify at this committee's hearing on campus sexual assault. During my time at Amherst College, from which I graduated in 2014, I benefited from decades of activism and legislation to promote gender equality on campus. But I also inherited a history of administrative under-enforcement, in the shadow of which gender violence was rampant, schools mistreated young survivors with impunity, and few students knew Title IX was about anything more than women's sports. On my campus alone, students who experienced sexual or dating violence were discouraged from reporting, denied counseling and academic accommodations, and pressured to take time off. When I reported my own abuse to my school, I was urged to drop out, go home, and return after my rapist had graduated. Nearly every day, Know Your 9 hears from students who have had similar experiences. And the hardest hit are often the most marginalized: students of color, LGBTQ students, low-income students, and students with disabilities. For many survivors, these inadequate school responses have not only frustrated their efforts to learn and graduate, but have also come with staggering financial burdens. The costs of violence are very real, between the expense of health services that colleges have refused to provide and tuition lost when victims feel they cannot safely remain on campus with their assailant without administrative support. These costs impact survivors' educational opportunities while in school and continue long after graduation. Many survivors' grades plummet when they are forced to study in libraries with their abusers or when they suffer from depression and PTSD without administrative support, often leading to diminished wages long down the road. This intolerable status quo demands a strong federal response. Due in large part to the important recent guidance from the Department of Education's Office for Civil Rights, schools are finally beginning to take their responsibilities more seriously. Accommodations like housing changes and mental health services may seem trivial to the outside observer, but to student survivors across the country, they are making the difference between staying in school and dropping out. Title IX is a powerful tool to keep the 1 in 5 women who will suffer gender violence during college in school and learning. In reauthorizing the Higher Education Act, Congress should build on previous efforts in order to continue the fight to end violence and discrimination in higher education. I outlined a number of solutions in my written testimony, but here I am going to focus on 2: mandating campus transparency and promoting effective enforcement of Title IX through fining authority and funding for the Office for Civil Rights. First, transparency. There are strong, perverse incentives for schools to sweep violence under the rug. A school that provides clear pathways to reporting may see an increase in the number of people disclosing assaults, and hence a spike in its assault numbers under the Clery Act. This could make the school seem unsafe compared to a school that discourages reporting. To counteract these potential negative reputational consequences, Congress should mandate that all schools conduct yearly campus climate surveys and publish the results. It matters how these surveys are instituted. Infrequent climate surveys, or surveys where the results for each campus are not made public or are released merely as aggregate data from numerous schools, will hinder our efforts to create safer campuses. Each school should also be required to publish aggregate statistics on how and how promptly investigations are being handled. Together, this information will help students and families assess how each school handles these cases in practice and will give policymakers the data they need to continue shaping legislative solutions. Second, Congress should act to strengthen federal enforcement efforts. The Office for Civil Rights currently relies upon the empty threat of revoking all financial support from a college or university to motivate schools to comply with the law. But this is a nuclear option, too disastrous to ever be implemented. Providing the Office for Civil Rights with the explicit authority to levy fines against schools that violate the law would give the agency the increased leverage necessary to hold schools accountable without devastating programming and aid for students in the process. Crucially, this authority must be made available for the department to enforce all relevant civil rights laws to ensure that students are free from all forms of discrimination, including those based on race and disability. I also want to point out that serious efforts to combat violence on our campuses will require increased appropriations for the Office for Civil Rights. As more survivors come forward and the number of complaints grows dramatically, OCR remains grossly underfunded and understaffed. Increased funding would allow OCR to provide additional technical assistance to schools on how to comply with Title IX, to better inform students about their rights, and to improve campus safety by ensuring timely investigations. Over the last 5 years, we've seen a remarkable transformation. Conversations about gender violence once were confined to whispers in dorm rooms. Today, survivors and advocates like me have the opportunity to discuss these urgent issues before this committee. Thank you for your time and for your commitment to building a future where students can learn and thrive free from violence.
Thank you so much, Ms. Bolger, for your testimony. It's so important that we put a human face on this problem, as I told you before the hearing, and that is what you have done today. I so admire that you turned your horrendous experience into advocacy so that others don't go through what you did. So thank you for being here today. It's appreciated. Ms. Stafford.
Good morning, Chairman Collins, Ranking Member Murray, and members of the committee. I appreciate the opportunity to join you to briefly discuss the requirements of the Clery Act, including the newest requirements added by VAWA amendments, in addition to what institutions are doing to make campuses safer. I have a unique perspective on all of this, as I had the opportunity at the George Washington University to serve as the chief of police, where I founded and supervised a sexual assault response team for almost 20 years. And it is not a common model for a chief of police to also supervise a sexual assault advocacy group. This model worked at GW because of my passion for wanting to ensure survivors of sexual assault were not re-victimized by our response, processes, or actions in dealing with what I consider to be one of the most personal violations a human being can suffer. We dealt with over 250 cases during my tenure at GW. That said, I know firsthand that campuses expend a significant effort and resources in bolstering campus safety, ranging from implementing physical security systems to developing operational policies and procedures to plan for emergencies and crisis scenarios, and providing a myriad of educational programs to enhance knowledge and awareness regarding crimes on campus. Campuses form committees, teams, task forces, and town-gown organizations to resolve pressing issues related to campus safety, and they consider best practices and research in formulating effective prevention and response strategies. A cornerstone of campus safety efforts involves compliance with the Clery Act. The Clery Act requires all eligible institutions to comply with a constellation of annual, ongoing, and immediate requirements. Some of these requirements include identifying all campus security authorities, or what I like to call mandatory reporters of crime, and developing a system to gather crime statistics from all of those people on campus identified as CSAs. This is a significant task. For example, a small residential college would typically have between 300 and 500 CSAs who have to be trained in their responsibilities as mandatory reporters of the crimes that they become aware of. Publishing and distributing an annual security report. These reports must currently include 111 separate policy statement disclosures and 3 years' worth of crime statistics for the 15 Clery reportable crimes. Campuses have to quickly alert the campus community via a timely warning notice of reported Clery crimes that may pose a serious or continuing threat to the community, and they have to immediately alert the campus community via an emergency notification of any reported or potential incidents that pose an immediate threat to health and safety of the community. And they have to create and maintain and make available a written daily crime log, just to name a few of the requirements. The Department of Education has published a 300-page handbook as a resource for institutions to comply with this incredibly complex law. The handbook contains many rules and many exceptions to those rules. To Clery compliance officers, the handbook feels as clear as the U.S. tax code. In 2013, VAWA amendments to the Clery Act added 47 new policy statement disclosures to the law. There were previously 64 disclosures, effectively doubling its requirements. The new policy statements largely require institutions to develop, implement, and disclose very specific procedures the institution will follow upon receipt of a report of any VAWA offense. VAWA also includes the new requirement to report crime statistics for domestic violence, dating violence, and stalking incidents, and includes 2 new categories of hate crime reporting. Information concerning the victim's rights and options must also be provided in writing to students and employees reporting VAWA crimes. A new addition per VAWA, and in my opinion the most important one, is the mandate for institutions to provide education efforts around prevention and awareness of sexual assault, domestic violence, dating violence, and stalking. These programs for current and new students and employees must address a significant amount of required content, i.e. the educational programs are now prescriptive, which I elaborate on in my written testimony. Title IX's indelible influence can be seen throughout VAWA amendments. Many of the requirements under Clery have been adapted, often wholesale, from the pre-existing Title IX sub-regulatory guidance and elevated them to VAWA's implementing regulations such that they carry the force of law under the Clery Act. Specific examples of overlap between the laws may also be found in my written testimony. Campuses earnestly want to comply with the Clery Act, and many see it as a basement, not a ceiling, of campus safety efforts. Many of the new requirements proposed by CASA are laudable and have potential to enhance existing safety on campus. Each of these proposals will require thoughtful consideration of implications, intended or otherwise, of adoption, especially from a practitioner's perspective. As professional association representing Clery compliance officers and professionals, NACOP welcomes the opportunity to be involved in any efforts to help consider the practical implications of the proposed new legislation and any of the Department of Education's efforts to provide much-needed guidance and resources to institutions as they endeavor to comply with this law. I sincerely appreciate the opportunity to address the committee today, and I welcome any questions you may have of me.
Thank you very much. Ms. Flauelacher.
Good morning, Chairman Collins, Ranking Member Murray, and members of the committee. Thank you for inviting me to testify today. I am Molly Flounlacker, as mentioned, Associate Vice President for Federal Relations at the Association of American Universities. I am also the project manager for the AAU Sexual Assault Climate Survey. I have also been a college student and am now a mother. I care deeply, both professionally and personally, about this issue, and I'm proud to be a part of this effort to confront it. In my remarks, I am going to outline 6 points for you on this very important subject. Number 1, presidents and chancellors of AAU member universities have long identified sexual assault on their campuses as an extremely important issue that they need to face head-on. It is the issue that is keeping them awake at night. I have spent more time talking with our members about this issue than any other issue over the last 18 months. University presidents make it very clear, one sexual assault on their college campus is too many. One of the most important goals of our universities is to make their campuses a safe place for students to learn and succeed. Number 2, individual sexual assault cases can be complex. Schools take very seriously their responsibility to educate students about awareness and prevention, to encourage students to report sexual assaults, to respond compassionately and seriously to the needs of survivors, and to ensure that all students have access to fair, prompt, and impartial campus disciplinary processes. Number 3, in keeping with its mission as an association of research universities, AAU decided to take a research-based approach to help its members understand both the attitudes and experiences of their students with respect to sexual assault. Accordingly, AAU created and implemented a sexual assault and misconduct climate survey in consultation with a leading outside social science research firm, Westat. The survey was developed by Westat and a multidisciplinary team made up of recognized experts across the country. Nearly half of the AAU membership has administered the survey this spring. AAU will publicly release the results this fall and hopes it proves first and foremost helpful to schools, but also to policymakers in the legislative arena. The data will also be made available later to the research community, which we expect will be a significant resource to better understanding this issue. Having spent the last 15 months on this project, I can say it is an extremely complicated process. Moving forward, we want our experts to be a resource for Congress as they work through this issue in the Campus Accountability and Safety Act in particular. We want to get this right because we strongly support the use of climate surveys on college campuses. Number 4, the legislative and regulatory landscape around campus sexual assault is incredibly messy because of the number of different federal laws and now state laws, regulations, and guidance, as Chief Stafford articulated. Overall, we believe that schools need a framework of clear and consistent standards with flexibility when appropriate, so that they have the necessary tools to better protect students and support survivors. Number 5, AAU strongly supports the goal of the CASA bill to better inform and protect students, including core elements of promoting the use of the Campus Confidential Advisor and Campus Sexual Assault Climate Survey, for example. We support and appreciate many of the changes that have been incorporated into the current version of CASA. There are still some areas where we have remaining concerns, primarily because of unanticipated effects on students, as outlined in my written testimony. For example, we strongly support giving survivors of sexual assault access to a trained confidential advisor whose sole responsibility is to counsel the survivor. This is in the best interest of the survivor. Any requirements that the advisor act in an investigatory role or reporting role could compromise confidentiality, both under state law and FERPA, and increase the likelihood of the advisor being subpoenaed in subsequent legal proceedings. Absent clarity in the statute, it's inevitable that new duties will be assigned to the individual by the Department of Education as they implement the law. We are also concerned about potential conflict with the advisor's responsibilities in CASA and schools' current Title IX reporting requirements. Again, the sole responsibility of the advisor should be to counsel the survivor. Lastly, sexual assault is a societal problem. As important as it is for colleges to confront it directly, it does not exist in isolation on college campuses. We believe there is a role for the entire education community to play in producing cultural changes that reduce the incidence of sexual assault. AAU and the higher education community look forward to continuing to work with Congress and the administration to make students safer. Thank you again for the opportunity to testify. Happy to answer questions.
Thank you very much for your testimony. We have just been notified that votes have started. We're going to have 2 votes, and we'll have a recess while we do vote, but we will be able to continue for now and get through some questions before people have to leave to vote. We'll limit senators to 5 minutes on this round. I do also want to announce that Senator Alexander will be returning, and after the votes, he will take over as chairman. It's been a great experience, and I would have liked to have continued, but I will turn over the gavel, albeit reluctantly, to the legitimate chairman of the committee. Ms. Flounlacker, I want to pick up on a point that you commented on about the confidential advisor. I'm a strong supporter of the confidential advisor. I've been surprised when I talked to the University of Maine and other colleges that it turns out that this is not as straightforward as I thought that it would be. On the one hand, confidentiality really focuses on the victim, and that's what we should do. And it may encourage student victims to report violations and seek the help that they need. On the other hand, the requirements of Title IX and the Clery Act require various forms of reporting when crimes occur on campus. And indeed, the Department of Education's 2014 guidance says that, quote, there are situations in which a school must override a student's request for confidentiality in order to meet its Title IX obligations. So it seems to me we're putting schools between a rock and a hard place unless we get some clarity here. How can colleges and universities provide the confidential services and advising that many of us think are vital to students while balancing and meeting the requirements of both federal and, in some cases, state law and the desire to respond effectively?
I think, Senator, you've identified a very important issue. We want to get the confidential advisor right. It's an essential service offered to students. As you articulated, as I mentioned in my opening comments, we have concerns that as currently drafted, the advisor would be tasked with responsibilities that really go outside of what we think should be the core responsibility of counseling a student. And as you mentioned, in addition to our issues with any fact-finding or investigatory powers or reporting requirements, potential conflict with Title IX is a real concern and one that we'll have to address in the legislation in order to get this right. And part of the issue in the legislation, and if I'm getting too technical, please stop me, Senator. Part of the issue is that in the legislation, the advisor may liaise with an institution to make accommodations. So this would be changes in a dorm room or a change in classroom, for example. And it says explicitly it shall not trigger an investigation by the school. And clearly, schools are committed to providing accommodations and to maintaining confidentiality. The problem is many schools typically believe that if they're making accommodations for a student, it's sufficient to warrant an investigation by an institution. Moreover, as the senator articulated, institutions are required under Title IX to track and report accommodations provided in response to sexual assault. So there is a clear conflict here. I think that there are some solutions, and we'd very much like to be a part of that conversation. So, for example, it would be better for the advisor to let the survivor know where to go, who to talk to about making accommodations, rather than that advisor actually carrying through the process themselves. So I think that there are solutions here, and again, we just have to keep focusing on the core responsibility of the advisor, which is to counsel and make sure the guidance is very clear so schools know what they're doing and survivors understand what the advisor can do to help them.
Thank you. I'm going to ask the rest of you to respond for the record to that issue, because I think there is a clear conflict between the rules and the regulations. But I want to get quickly to a second topic in my remaining time. Ms. Bulger, we have climate surveys that our military academies do, and they have a very high response rate because the students know that they are expected to fill out those climate surveys. That is not necessarily the case for private colleges and public universities. What suggestions would you have to encourage students to participate in the climate surveys so that they're meaningful?
Thank you for that question, and it's a very good one. I think that in thinking through climate surveys, we have to remember that this is just one piece of a larger effort to change the culture around sexual violence on campus. And so that means doing education work and outreach and training to students that raises the profile of them of this issue and helps them understand how incredibly important it is. I think we have, to be honest, seen a lot of change on campuses over just the last couple of years as students' peers who are survivors are coming forward and telling their stories publicly. And so I suppose I'm a bit more optimistic that students will want to be part of the process to complete these surveys. I do think that we should certainly build on existing structures on campuses, existing structures of students. So we have fraternities, we have sports teams, we have sororities. These are groups of people who already come together around shared values. And I think that if we can create buy-in among people in those communities, we will see much higher response rates to these surveys.
Thank you. Senator Murray.
Thank you very much, Ms. Bulger. I want to just start by saying how much I admire you for your courage and how much I appreciate the work you've done to empower other students and survivors, and creating the Know Your Nine organization is just really valuable. So thank you for that. I did want to ask you, given the fact that sexual assault is such an underreported crime to law enforcement, what do you think is the most important step for universities to create to get a survivor-focused approach?
Thank you for that question and for your very kind words. I think first off that survivors need to know what they can expect to receive out of a reporting process. Schools need to ensure that the existence of accommodations and how to access them is clear, well-publicized, and well understood on campus, and then of course need to follow up and actually issue those accommodations and protections to students who request them. I know a number of survivors on my campus simply didn't report because they didn't understand that the school could be useful in helping them change a dorm that they shared with a perpetrator or switch out of a class section that they shared with their abuser. I think the second point I would make is transparency. We've spoken a little bit about climate surveys. I think it's also incredibly important that schools release aggregate data about the results of disciplinary hearings, how quickly they're proceeding. Of course, this shouldn't be identifying information just in aggregate, but I think that will help survivors build confidence in the system and trust that schools are there for them and that they want to help them.
Great, okay. You know, sexual violence is a significant health problem in our country. According to the CDC, nearly 1 in 5 women is sexually assaulted in college, and it's oftentimes by someone that's known to the victim. It's a former partner or a friend or acquaintance, someone they knew in a class. I know that UC students and faculty and their president have taken the issue of addressing this head-on. They've formed a system-wide task force to improve the community and make campuses safer. President Napolitano, I wanted to ask you, how has the UC focused its efforts on making sure the focus is not only on improving universities' practices in response to sexual assault and violence, but also on working towards a culture of prevention?
Thank you. I think it begins with raising the issue. As I mentioned, from the first day a student shows up to start, they will be given specific training on this. They'll also be made aware of what resources are available to them if something were to occur, where to go, who are the independent advocates, what they can do. We see the independent advocates as really acting as gatekeepers, not as reporters per se, but really as gatekeepers for the student in terms of, do you go to the campus police? Should you go to your department chair, et cetera? And then to be there to do appropriate follow-up working with the student. But it begins with creating that culture from the day they begin on campus, and then consistency and persistency throughout the college experience.
Okay, and really quickly, because I know we have a vote, in fall of 2014, I know that California became the first state in the country to enact a yes means yes law defining sexual consent. Can you talk with us about how this affirmative consent law is empowering students and faculty?
Yes, and because we had actually changed our policy before the law changed, so we've had a year's worth of experience with it. It really, in a way, shifts the burden so that the survivor isn't the one always trying to explain what happened. And it means that consent has to be knowing and intentional. If it's not valid anymore. And that gets incorporated into all of the training materials.
Okay, very good. Ms. Bolger, can you share with your thoughts with us on how a standard like yes means yes could help on campus sexual assault?
Of course. I think affirmative consent is a strong, important policy that will that reflects students' values already around how they want to engage in relationships with people in their community. I do think that affirmative consent will only be successful if there is education for students about what the expectations are, how to obtain consent. Students enter college with a wide array of understandings of what consent is, and I think that orientation programming and continuing ongoing training for students, as well as for the people who will be hearing these cases and investigating these cases, is absolutely necessary to make sure that this becomes common and expected on campus.
Okay, thank you. Thank you very much.
Senator Cassidy.
Ms. Flounlacher, Senator Gillibrand circulated some statistics suggesting that 41% of campuses, and I can't verify this, but she circulated this, 41% of colleges and universities recently surveyed have not conducted a single investigation of sexual violence on their campus in the last 5 years. Wow, that seems like there's a problem with the universities communicating to their students that this is reportable. Do you follow what I'm saying? And I can't independently verify that, but I got a daughter at a campus. That seems like a problem with universities. Is that a fair statement?
Well, thank you for the question, Senator. And I can't speak to the individual statistics. I'm not an expert in that arena. I will say that our schools are taking this very seriously, both to explain the process, to explain how students can report, and explain what happens in a disciplinary process.
No offense, but if that statistic is correct, and I don't know if it is, if 41% have not investigated a single incident, but it is as prevalent as Senator Murray suggested, that tells me they're not taking it seriously. Because that which is measured is addressed. It tells me they're not measuring it, or if they are, they choose not to address.
Right.
And you can't speak for all 41%, but it still seems like we've met the enemy and he is us.
Right. Clearly, in all candor, is the system perfect? No. Are mistakes made? Yes. Every system can be improved. I don't think there's a president or a chancellor that would disagree with that statement. And I'm not justifying again the statistic. There may be truth to it. There may not be. I know that there are a lot of reasons why cases don't go forward. So sometimes the context is really important. There are cases where survivors don't necessarily want to go forward. There are not enough facts for the case to go forward. But again, I can't speak to the specific statistic.
Okay.
I do know, just speaking, if I can just say, speaking from the association, presidents recognize, most importantly, the need for better data, which is where our climate survey comes in. It's really important that we understand how students
Can I stop you just because I'm almost out of time, and as you can tell, everybody's left me. So, Ms. Napolitano, you've got so many titles, I don't know which to refer to you as. But you mentioned there should be a difference between the UC system, a big state university, and the small liberal arts college. Could you elaborate on that difference in approach?
Right, the principles are the same, but for example, big systems like mine, we have our own police departments. They're sworn officers. Small colleges may not have any sworn officers on their staff. Should we be required to have separate MOUs, or do we start with our own police departments? These are the kinds of things that are different between campuses.
And let me ask you something different. There's
Sure.
been some high-profile stuff recently about the accused who felt as if they were wrongly accused and did not receive due process from the university. Again, I can't attest to that, but in our democracy, you're innocent until proven guilty, that sort of thing. Do you have thoughts, or to others, how do we also, for those who might be accused wrongly? Because I actually know a woman who's now being accused, and she swears she's accused wrongly, and yet her entire career is in jeopardy because of this, and she feels as if she's not been accorded rights. Thoughts about how we address that issue?
Right. We're actually looking into that right now. How do we make sure the system is fair to both sides? Actually, when I look at the litigation that's been filed against the University of California, about half of the cases have been filed by survivors and half by respondents who say they weren't treated fairly. So there's a lot of controversy in this area. One of the issues we're looking at is, do we provide, or what kind of support do we provide to a respondent in addition to a complainant? Right now, we provide the support to the complainant. So do we provide the exact same thing to a respondent? If not, what do we provide for a respondent?
Now, some of the stuff I've read suggests that it should actually leave the university system and go to a civil court, because that's the only way you ensure that you get fair treatment for both parties. Again, I'm looking at 41%. If that statistic is true, it tells me that for a sizable minority of the universities, there's an inadequacy of approach, whether it is for either party. Any thoughts about that?
Well, I think if you made it mandatory that these cases go into either civil or criminal court, that would be a deterrent to complainants coming forward at all. So I think I would be very cautious about any kind of mandatory referral process.
Gotcha. My time is out. I am to announce the committee stands in recess for senators to vote, and will resume shortly after votes have ended. Thank you each for your testimony. I just can't thank you enough.
The committee will come back to order. Contrary to my expectations, although the chairman has returned, he has very graciously agreed to allow me to continue wielding the gavel, and so I'm feeling extremely powerful until such time as I have to leave, and then he will resume his rightful place as chairman of the committee. But I thank Senator Alexander for his courtesy on an issue that matters a great deal to me. Senator Bennett, we had left off with your being next.
Thank you, Madam Chair, and thank you, Mr. Chairman, for allowing the senator from Maine to continue her able chairing of this hearing. And thank you to the witnesses for being here. Ms. Bolger, in particular, thank you so much for your testimony. I wonder whether you mind touching on something. You touched on your written testimony, but not, I think, in your oral testimony. That is your views on mandatory referral laws and how we should think about that, and policymakers at the state level should think about that.
Yes, absolutely. Thank you for the question. Are you speaking about mandatory referral laws to the police?
Yes.
I think that's a wonderful question, and one that many people have. I get asked all the time why campuses are dealing with this in the first place, and why don't we send reports to the police? And I think that that's a really intuitive question, but the reality on the ground is that survivors tell us again and again that were their reports to schools forced to go to the police, that they would report to no one at all. In fact, 9 in 10 survivors told us that if their reports were turned over to the police without their consent, they expect fewer victims would report. And so if we are serious about reducing violence on our campuses, perhaps counterintuitively, the best thing to do is to empower survivors with the right to decide who receives their reports.
Does anybody else want to touch on that? Or let's stick with you then, Ms. Bolger. You did such a great turn of phrase, the reality on the ground. Are there other things that we should be thinking about that either might be counterintuitive or not, but in terms of the reality on the ground as we act in a well-intentioned way, but in a way that could be counterproductive?
Oh, that's also a wonderful question. I think the first thing that comes to mind is that we're hearing a lot on college campuses about sexual assault and how schools need to take sexual assault seriously. And that's true, and I think that that is starting to happen. I think that there's a real gap, though, between responding to sexual assault and responding to other forms of gender-based violence. So I'm talking about dating violence, intimate partner violence, stalking. The new components of the Clery Act will require schools to report incidents of dating violence, domestic violence, and stalking. But it's critically important that schools address these issues in their policies. Policies for dating violence survivors can look really different than for sexual assault survivors. Things like providing free transportation to a local court to obtain a restraining order, not penalizing survivors for missing class in order to obtain a restraining order, things like that.
Are you aware, or is anybody else on the panel aware of, is there a designation somewhere of universities that have set the gold standard for dealing with sexual assault and sexual violence on campus? Is there some standard that students have established or community groups? I mean, I'm just trying to think about where we would find the best practices if we were looking, probably at the University of California, I'm sure, but where else? Madam President.
We aspire to be the gold standard, but we know we have more work to do. I think every campus in the United States recognizes that, but I think we certainly have taken this on as a major issue for our students and for our campus community.
If I could add, Senator, I think you raise a really important question, and it speaks to the section of the CASA legislation for a grant program, which we think is really, really important, particularly focused on more research on better awareness and prevention, which I think our schools are very engaged in on the research front, but we need more of it so we can identify better best practices. I think everyone can agree with that point. In an ideal world, I think with the grant program in the legislation. We would want a dedicated funding stream for this kind of research rather than using funding from the fines to go into the grant program. We would prefer a dedicated funding stream just for this kind of important research.
At least from where I sit as a recent graduate and a survivor and an advocate, I don't think that we know that any school is getting it right perfectly. There are certainly schools with strong policies, but until we have more information and more data, like what we could obtain from standardized climate surveys, I don't think that we're going to have a good sense of what policies are necessarily working best until students tell us.
Governor, you get the last word.
I'm sorry. It goes to the point of flexibility in legislation because evidence-based, data-driven best practices will change over time. And I think what the law wants is for us to use data-driven best practices and to be able to demonstrate that that's what we're doing.
Thank you. Thank you, Madam Chair.
Senator Warren.
Thank you, Madam Chair. And also thank you, Mr. Chairman, for holding this hearing today. It's a very important hearing and really appreciate both of you for doing this. We've talked about the numbers. According to the CDC, an estimated 19% of women will experience a sexual assault while in college. 1 in 5 women means something is very, very wrong. Students, all students, should be safe on campus. Now, Ms. Bolger highlights the importance of climate surveys and particularly the importance of making the data that comes from those public, and I strongly support this effort. Good data can be an important foundation for change, and as you've said, if no one knows what's going on, then there won't be any change. We've also talked about how colleges respond to reported incidents of sexual assault, and I think that's very important. A school's response should be timely, should be appropriate, should be respectful. But I want to ask about work to prevent sexual assaults in the first place and how the federal government can help. Chief Stafford, in your nearly 30 years serving in campus law enforcement, what did you or GW's administration do that proved effective in preventing sexual assaults on campus?
I think the education efforts have to start with, we often focus the education efforts on women because we assume that generally women are more frequently the victim of a sexual assault than men. But I think we have to focus our education efforts on men. And we need to do that when they're, quite frankly, when they're in high school. We should be sending men to campuses who understand respecting a woman, understand what consent is. I have huge concerns about the level of understanding, and I have friends with teenage boys, and I talk to them about their level of understanding of consent, and they don't understand consent. And so I think the education efforts really need to be focused not only on women and not becoming the victim of a sexual offense, but on men and not victimizing women. I think it needs to go both ways.
Ms. Bolger, would you like to weigh in on this, focusing just a bit more on the prevention part of this?
Sure. So I think the most important thing about prevention education is that it starts early and it just keeps going. We need consent education and healthy relationship education in middle and high school and college. It needs to start the week that first years get to campus, and it needs to continue. I know that I had no recollection of any sort of orientation or education programming I received around this because as a first year, in your first week, you're getting bombarded with so many messages and so much information. And so it needs to be ongoing. I see a lot of schools trying to slide by doing online prevention education. Mm-hmm. Online prevention education is not education. It needs to be in person. And I think that it needs to be looking at the issue both from a skills and information-based level, telling students about their rights, telling students what consent is, and also needs to be looking at it at a cultural norms, values-based level, talking about sexism and violence more broadly.
Mm-hmm. President Napolitano, can you tell us a little bit more about what you've done on the UC system, what you've found effective or not in terms of prevention?
Again, it's an evolving area. In-person education online supplements, complements, those things can happen together, experimenting with peer-to-peer education programs, bystander education, so that the overall campus community is more aware of what it should do if they are witness to an event. So those are the kinds of things that I think improve the overall climate.
So I'm getting low on time here, but let me just ask this question because of where we are today. Where is it that the federal government can be helpful in this part of the making campuses safer? What is it that we should be talking about and thinking about here at the federal level? And I open this to anyone who'd like to respond. Don't all jump in at once.
I'd like to talk about, for a second, about the issue of the MOUs that's in CASA, because I think the reason sexual assault survivors have been unwilling to report sex offenses to local police and campus police is because they're uncertain of what they're going to face and what they're going to deal with when they make the report. Are they going to be believed? Are they going to be challenged? Are they going to be made to feel irrelevant? I think having or not having an MOU isn't going to change whether a survivor reports the incident to police or not, but most campus public safety leaders I know have requested MOUs of their local police, and the local police, if they have one, it's because the local police were willing, and if they don't have one, it's because the local police weren't willing, and there's nothing behind that, there's no teeth behind it that forces them to engage in getting into an MOU with a local police, with the campus police department. So I would like to see something that actually forces the hand of local and state police agencies to actually engage with the campus police agencies. Because I know in DC, every time there was a new chief of police, I went to them and asked for an MOU.
All right.
Every time I was refused.
That's a very helpful point. Did anyone else want to say something quickly? Because I'm out of time now.
I would just say very briefly that the two most important things from my perspective as a former student and a survivor is mandated transparency from schools so we know what's actually going on and prospective students and their families know what to expect, and enforcement from the Department of Education. Students have really felt alone on their campuses in trying to deal with this, and if the Office for Civil Rights can continue to step up, I'm confident things will change.
Thank you. And since I'm out of time, I'll just add this as questions for the record, but thank you all very much. And, we've got to do everything we can to keep everyone safe on campus, and I really appreciate your being here today. It's our job to do what we can to help. Thank you. Thank you, Madam Chair.
Thank you. Senator Baldwin.
Thank you very much, and I very much appreciate the scheduling of this hearing. I really want to thank our witnesses today, both for your time and your testimony, but also for your life's work and energy devoted to advocating for others and improving the climate on our campuses across the United States. I wanted to start with a question about the climate survey. We just had a question before our break about bolstering participation rates. And in addition to that, I guess I wanted to, first of all, recognize that the Association of American Universities has been active in developing and beginning to implement a sexual assault campus climate survey. I'm proud that one of the campuses in Wisconsin, the University of Wisconsin-Madison, is a part of this effort. And as I understand it, the results of this survey are due in the fall. But I would hope that you could perhaps share some of the lessons that AAU has learned in its implementation, and especially if we are to look at including a climate survey as we reauthorize the Higher Education Act. We want to garner the best and latest information. And then I'm going to turn, after Ms. Flaunlacher speaks, I want to ask President Napolitano, I think the first point you made in your testimony was the flexibility, recognizing differences in campuses and how that might inform the content of a climate survey. And I wonder if you can be more specific about how you would alter the climate survey from campus to campus, or what we should be thinking about. But let me start with you, Ms. Flaunlacher.
Thank you, Senator, for a very important question. This is a top priority. Our presidents and chancellors asked for better data on this issue, and we are delivering through the survey. As mentioned, we will produce the aggregate results in the fall. We've encouraged all schools, and I am confident that all will produce their own results as well. And I'd like to offer some specific comments. The first has to do with response rates. It's an issue that you raised, and actually Senator Collins raised as well. And it's a really important issue. I think colleges, with any survey, want to ensure as high of a response rate as possible, particularly with a survey of this nature. And unfortunately, schools have no legal authority to force, to compel students to participate. Having said that, and I have seen this now firsthand through our survey, there are a number of strategies that schools can employ if the survey is locally administered. So if the school itself administers the survey versus in the CASA legislation, the Department of Education would administer the survey. So that's one of our concerns. But if the school administers it, then they have control over a whole host of issues. Who promotes it, how it's promoted, when, how long, whether incentives are used or not. And there is a solid research-based group of evidence that talks about strategies that really can bolster response rates. So that's an area that I think we know a lot more about now, and AAU can be a great resource moving forward. If I have another minute.
Wait, because I do want to.
Okay, all right, I'll stop there, and if there's more time, I can comment more.
Well, and I think her answer illustrates the point I was making about flexibility. How a survey administered from a federal department is a lot different than one administered on your own campus, and how a campus administers it and the incentives it uses and what it does to increase the response rate can be very specific as to a campus. I think the same thing could be said to content as well, as long as certain subject matter areas are covered. And then the third thing is that you can get campus climate through a variety of measurement mechanisms. We were talking during the break about focus groups to supplement surveys that give you students a greater opportunity to discuss. And we know this from politics, where a poll just tells you X and it's a snapshot. A focus group gives you an opportunity for a longer discussion. So the result is for national policymakers to know what's happening, parents to know what's happening, students to know what's happening, but also campus leadership to know what's happening on their campus so they can take immediate action.
Thank you. I noticed that I'm about to run out of time. I would ask that you do indeed follow up to make your additional points, and if either Ms. Bulger or Chief Stafford have additional comments on that question, I would appreciate it. And just let me note, the other question I intended to ask but won't have time relates to the fact that we are looking at flat funding the Office of Civil Rights in the Department of Education, which is tragic to me in terms of how important you have articulated in your testimony adequate resources are there. And I would love to hear from all of you on what impact that will have on institutions as well as students.
Thank you. Senator Casey, you missed my lauding you in my opening statement, so know that it occurred.
Senator Collins, thank you, and I appreciate that, and I appreciate what you have said and what you've done on this issue, and Senator Murray as well, the commendation, but also the work in leading us in this hearing today. And appreciate all of our witnesses who have labored in the vineyard a long time, if I can use a line from the scriptures about this issue. It's an issue that I guess for far too long we haven't been willing to confront as a country, even though it's one of the most profound betrayals you can imagine. It's a betrayal when you send a daughter to a college, and I've sent two and I have two more, but when you send a daughter to a college and you tell them to study hard and that they're going to have a wonderful experience, one of the best experiences of their life in most cases, and then the system betrays them. The school lets them down, the government lets them down. So when I say betrayal, I think we all, not everyone in this room, but a lot of us share in that. And I think we have to be very, not just determined, but I think we have to be very insistent on following rules and demanding a lot more of our schools than we've demanded up until now. I think it's a matter of basic justice. In the Bible, they talk about people hungering and thirsting for justice. Well, in this case, they have not been satisfied. Victims have not been satisfied, families and communities. So we have a long, long way to go, and I'm very proud of the work that I did and others did to get the recent changes through VAWA, get them through the regulatory process and have them not just law, but law that's being implemented by way of regulation. I know there's some discord about the result of that. We'll get to that in a moment. But I think the last thing I'd say, and I'll submit a longer statement for the record before questions, but this has to be a priority for men. Men have been on the sidelines too long. Too many young college students standing at parties knowing something's going to happen or having a sense that it might happen, having a sense of what their friends could do, and just walking away or not doing anything. So in some ways, as much as the system has betrayed women on campuses, a lot of guys have betrayed them as well, sometimes their best friends. And so, Ms. Bolger, when you testified, we're grateful that you did that. I can't even begin to imagine how difficult it is to have lived through what you've lived through and then to come before a public audience like this, and it may not be the first time, but it's of great value and benefit. So we need to learn, not just learn from you, but be inspired and try to move this issue forward in a way that's commensurate with the spirit that you've brought to it. So I wanted to ask you first a question about, in your experience working with survivors, and one of the challenges here is reporting, and if you could walk through, in your experience, why victims sometimes have the great difficulty of reporting.
Thank you for that question, and for all your work on this issue. It means so much to survivors and to students. There are a whole host of reasons why it is challenging for survivors to report. The person who assaulted them is likely someone they know, a friend, a partner. It's incredibly difficult to take a person you love and trust, have this happen to you, and then report them. Many survivors fear reporting to the police for any number of reasons. They may be undocumented. They may come from already over-criminalized communities. For some survivors, reporting to the criminal justice system won't do anything for them because their states don't even recognize what happened to them as violence. I think it's incredibly important at the campus level that schools are open and transparent about the kinds of protections students can expect to receive by reporting. It's hard to report if you don't know what could come of it and how that could help you continue your education and feel safe on campus.
Mm-hmm. Well, we appreciate that because one of the things we tried to do in the Campus Save changes is to take that into consideration. I appreciate the input. Secretary Napolitano, we're grateful that you're here today and grateful again for your service, continuing service now in the field of education as you did for the country and for your home state. I guess one question I have for you is, what are some of the lessons learned as a leader of a major institution, confronting this and trying to deal with both the reality of the problem, but also the complexity of trying to make the changes that you hope to make and that you have made?
I think one lesson is, how do you take a large system such as a university system like the University of California and a major issue that is, as I mentioned, it's cultural, it's health, it's criminal, and organize it in such a fashion that you can take implementable steps on each one. and work your way through a program and evaluate it as you go along as to whether you are really doing what survivors need and what justice commands. One point I wanted to add, and that with respect to what students have told me on the reluctance to report, is the issue of confidentiality. Mm-hmm. Is the confidential advocate truly confidential? And having to be, and the law needing to be clear about when we have somebody we brand as the confidential independent advocate, well, does that person also have reporting responsibilities? If they do, that undercuts the nature of confidentiality. And I think there's a lot of confusion in that area in the law right now.
I know I'm out of time. I'll have some more questions for the record. Senator Collins, Senator Murray, thank you very much. And Senator Alexander.
Let me, I know Senator Collins has to leave. I had expected to be in Nashville at a funeral today and was told the vote might be close on the highway bill. So that's the way the Senate works. I came back, but I thank Senator Collins for, in a short period of time, preparing herself and using her usual diligence to chair the hearing. She has a background at Husson University. We're all experts on education, but she actually worked at university, Husson College or University. And so I thank you very much, Susan, for taking time to do this. And I know that you have to leave, and we'll wrap up the hearing now as you go. And we look forward to your advice as we continue with this issue. As I think you can tell from the comments of the senators, there's a good deal of concern and surprising amount of humility here, because in the sense that we're not sure we know what we can do to help you, and we certainly don't want to interfere with your efforts. And I think Senator Warren's question was a very good one. I mean, she simply asked, well, what can we do to help? And we'll be finishing our, Senator Murray and I will be working with our working groups on the reauthorization of the Higher Education Act this fall. We hope to complete that before Thanksgiving in the committee, and I'll have more to say about your asking for your advice. So thank you, Senator Collins.
Thank you very much, Mr. Chairman. It was an honor to substitute for you today. Thank you.
Senator Murray, do you have additional questions and comments?
Mr. Chairman, I just would like to ask unanimous consent to include in the record a statement from the Women's Legal Defense and Education Fund. And I will submit any other questions I have, but I want to thank all of our panelists today for their really expert testimony. This is an extremely important topic, and I think every parent who is sending a daughter or a son off to college wants to know that we are doing everything we can to make sure they're protected, and you all have given us great insight into how to do this correctly. Mr. Chairman, I look forward to working with you on this as we look at reauthorizing the Higher Education Act. Thank you.
Thanks, Senator Murray. I should add that this has been a priority of Senator Murray's from the day we started working together, and she's going to continue to focus on campus safety. We're thinking about a hearing coming up soon on that. I have 3 questions I'd like to ask the panel, and the answers can come later. But if you have something you'd like to say about it now, I'd welcome it. But question number 1 goes back to what I said a little earlier. The government has a way of expressing its concern in laws, rules, and regulations that aren't as efficient as the concern is real. In other words, we sometimes duplicate, and we sometimes cause campuses to spend more time filling up forms and working with students to, for example, have a session informing incoming freshmen about what their responsibilities are. Let me ask this. Would each of you be willing to give us specific suggestions about how you see Title IX and its rules and regulations, the Clery Act and the new regulations, how they could be improved, where they conflict, how they could be made clearer so that campuses would have the flexibility that you talk about, President Napolitano. I didn't know what title quite to give you there, but I'll call you President Napolitano. Would you be willing to do that and to give it to us in as specific form as you could? And if you have any comment you'd like to make about that, I'd be glad to have that.
Welcome the opportunity to do that.
Yeah, I mean, the University of California, I know that through your system, you're so large, and it's such a good system that you're bound to have plenty of people who are wading through all the federal rules and regulations, and just tell us, say, you know, this, we don't know what this means, and this duplicates this. I mean, you've been in so many different positions as governor in here that you know exactly what I'm talking about. And I think, particularly on behalf of all the colleges and universities, and we need that by around September in order to be able to include it in the Reauthorization Act if there's something that we need to do.
Chairman, if
yes.
I could just add, we would absolutely, as President Napolitano said, welcome the opportunity. And if I could go one step further, I think we should also pay close attention to the Department of Education and make sure, as the reauthorization process goes forward, that they do not issue any additional guidance without the comment, which is very standard rulemaking process, to allow stakeholders, both survivor groups, higher education, other experts, the time to ask questions, to clarify, as well as provide important expertise to ultimately shape the outcome we all want.
Well, I think that's a reasonable request. Several of us on the committee asked a distinguished group headed by the chancellors of Maryland and Vanderbilt to look at generally simplifying higher education rules and regulations and making them more effective. And one of their findings was that every one of our 6,000 colleges and universities gets, on average, every workday, one new guidance rule or whatever. So I will ask the department not to do that, especially while we're in the midst of the reauthorization of higher education. The other observation to make as a part of that is that only 15% of the colleges are private universities. We often think about those, there's a difference between Nashville Auto Diesel College and UCLA in terms of what we might be thinking about doing. So we need to keep that diversity in mind. A second question I would ask you: one college president, a very accomplished one, she'd been president of 3 different colleges, said, when I asked her what we should do about this, she said, you should focus on helping campuses better coordinate with law enforcement agencies, but do not turn colleges into law enforcement agencies. Do you have any comment on that? Ms. Stafford, I would think you might.
I absolutely agree. I think there's a reason for a campus process, and I think campuses certainly have a place in the process. I don't want to see them become law enforcement agencies. I think students have the right to choose whether or not they want to move forward with pressing charges, and if they do, law enforcement's there for that. I think the campuses provide an alternative for students as far as the disciplinary process, and I think VAWA has actually continued to strengthen that process. So I fully support not making campuses try to take the place of law enforcement. Law enforcement has a specific place, and they will do their job if called upon to do it.
I would concur and just say that, you know, the goal of the student disciplinary process is different than the criminal process. I think, however, there can be greater linkage between campuses and law enforcement in appropriate cases, and there are ways to do that.
The last question I would have is this. What can we do or not do to make sure that colleges establish procedures dealing with sexual assault that are fair and protect the due process rights of both the accused and the accuser? What should we keep in mind as we work on that issue?
Senator, that's something that we're looking into right now. What should be the rights of the accused? It does illustrate the difference between a student disciplinary proceeding and a criminal proceeding.
the right of the confrontation rights, for example. I think they should be different between those two things. We're working our way through that right now. It's a difficult issue, as you might imagine.
Right.
Go ahead.
Ms. Bolger,
I think the only point I would add is that Title IX already, as well as Campus Save, already requires schools to be fair and equitable in their processes. Know Your Nine sent a letter to university presidents asking for fairness and that they follow the law. I think it's critically important that that is the case, and I think at the end of the day, we're all really on the same page here. There's a way in which we like to pit people who care about survivors against people who care about accused students, but at the end of the day, this is about access to education, and I think that Title IX very clearly demands that all parties be treated fairly and equitably.
Thank you. Yes, ma'am.
I was going to make the same point Ms. Bolger made, and just might add that I think in the CASA legislation, through the reauthorization process, we need to make sure that any new training requirements for the confidential advisor, for example, doesn't contradict what's currently in law and with respect to fair and partial process. So I think training requirements is an area we need to pay particular attention to.
Thank you. Senator Whitehouse has slipped in under the wire. So we will, I'll call on him, and then we'll conclude the hearing. Senator Whitehouse.
Thank you, Chairman. Thank you for this hearing, and thank you very much to all of the witnesses who have been wonderful. I think given the late stage in the hearing, what I might do is offer a few thoughts and ask each of you if you would respond to them for the record, rather than extend this and perhaps run over my time. My first thought is that there is not good enough coordination between the Clery Title IX process and the ordinary and proper course of a law enforcement investigation, and that we need to find a way to disentangle those two processes so that they're not working at cross purposes with us. Too often we've heard about cases in which evidence is unnecessarily lost because law enforcement wasn't brought in at a suitable time. We've heard about instances in which the university process creates opportunities that are prejudicial to the victim in a later criminal justice process by opening avenues of cross-examination, for instance. And I think thoughts you have on how we better accommodate the law enforcement process in this, given that, to quote Senator Gillibrand, given the violent felony that this actually is, I think we need to bring law enforcement in as an earlier time, which brings me to my second point, which is that, in my view, the sooner we get law enforcement engaged in the process, the better. Now, the counter-argument to that is that in the past, there have been times and circumstances when law enforcement has done a lousy job of participating in these investigations. But I think the fact that law enforcement has done a lousy job on occasion is not a reason to keep law enforcement out. It's a reason to improve law enforcement in this area. I think we have a model with domestic violence. It wasn't too long ago when law enforcement was not helpful in domestic violence cases. Drive the guy around till he sobers up, ask the woman victim what she did to provoke him. We've learned a lot, and the domestic violence community, I think, has something to teach us about the integration of victims, advisors, and law enforcement early in the process. The third point that I'd ask you to respond to is that the primary concern that I hear on behalf of victims is that if law enforcement gets involved right off the bat, there's the risk that the victim will lose control over the proceedings. At a time when victims are already feeling that they've lost a lot of control and are feeling very vulnerable, that can be a very considerable threat. I believe that victims are often very poorly informed about the reality of a law enforcement intervention. Secretary Napolitano and I were both U.S. attorneys and attorneys general together, and you really don't have much of a case if you don't have a cooperating victim. So the likelihood of a criminal case being a vehicle for kind of running away with an unwilling victim is very small, and I think can probably be addressed. The concept, and I'll close with this, the concept that I am mulling is that at a very early stage in the report of an alleged assault, law enforcement would be involved. The police department would be involved. At a time before, unless there was some kind of immediate public safety emergency, I mean, there are times when you need to react, and obviously you shouldn't prevent that from happening. But absent that there could be a conversation in what, for want of a better term, you might call a sort of law enforcement vestibule, where the law enforcement officer comes out from his pure law enforcement role into the vestibule, sits with the confidential advisor, sits with whoever's handling the Clery piece, sits with the victim, and together they can walk the victim through what his or her real prospects are and what the real likelihood is of being run away with by a law enforcement investigation gone berserk, and what the real risks are of not reporting to law enforcement timely in terms of cross-examination vulnerability, what the real risks are of losing both electronic and biological evidence if time goes by, and figure out a way to make that happen. I worry that we're going to be in a situation in which the fears that have been justly provoked by clumsy, untrained, not trauma-informed, unexperienced law enforcement interventions in these cases are becoming an obstacle for a process where we could create experienced, trauma-informed, sensitive, effective law enforcement intervention at a very early stage. So I've run out my time, but I hope those are useful thoughts, and I hope that they're useful enough to provoke a response from you under our questions for the record rule in the committee. And President Napolitano, you're probably too busy to do this yourself, so I'd be delighted to receive a QFR response from whoever in the vast University of California system you delegate to handle this stuff.
I'll write it myself.
Chairman, thank you very much. You've known me too long to try to get away with that, huh? Okay, thank you. Good to see you here, Barry.
Thanks, Senator Whitehouse. I'd like to ask consent to insert statements in the record from individuals and organizations interested in the due process rights. We've received a number of comments on that, including from Judge Nancy Gertner at Harvard Law School, Janet Halley, Harvard Law School professor, and others. The hearing record will remain open for 10 days. Members may submit additional information for the record within that time if they would like. The committee plans to hold the next hearing related to the reauthorization of the Higher Education Act on Wednesday, August 5th, to discuss the status of student success at American colleges and universities and how to improve it. Thank you to the witnesses for coming. We appreciate it very much. Some of you have come a long way, and we know that you have other things to do, and this has been a big help to us. I thank my colleagues. The committee will stand adjourned.
Mr. Chairman, may I just make one final remark for the record?
Sure.
My Attorney General at home, Peter Kilmartin, has convened a group of folks from domestic violence victims organizations, and Rhode Island has a really rich and robust higher ed community that is all participating in a very, very good way. And I just want to, on the record, commend Attorney General Kilmartin and the higher ed and victims community in Rhode Island for the really terrific local work that they're doing that is helping to inform what I'm doing here. Thank you for the courtesy.
Thank you. The committee is adjourned.